Are there any other witnesses in opposition? All right, we'll bring it to the membership. Let me ask the first question that may be the most obvious. This is a committee that is very concerned with both privacy and grants of immunity, in part for the reasons that were articulated, is that when you grant immunity, there's really no incentive or very little incentive to protect those issues for which you no longer have any liability. Would you respond to that, if you would, and address that issue as specifically as you can?
Absolutely. Thank you, Madam Chair. I think actually the opposition mischaracterized two parts of what the bill does. First, by saying that we have sole and complete discretion. I understand where that view may come from because of the language of the state law, but fundamentally, if you understand this landscape, it's federal law that controls when this can be released. And federal law very specifically says that you cannot release it without consent. In fact, it's that federal law that controls our service providers that have made us put in a little bit of a bind when people come and ask for information about decedents. We have to tell them, we have no authority to give it to you under federal law unless you can prove consent. The bill is designed not to give us discretion, but to make sure that there is a process where if you want the content of an electronic communication, you have to show consent. Nor do we have complete immunity, as both of the opponents testified. There is a good faith following the structure of the bill that is required before you get the immunity. And as we all know, even immunity under state law does not protect you if you violated federal law by disclosing content without consent.
And Madam Chair, if I may, and just in response to a couple of comments that were made, just to be clear, comments were made that they weren't involved in the process at all, which we disagree, because just to begin with, they were never groups that were either in support nor were they in opposition, and they were neutral. And we made the commitment to this committee that we would work with those that were in opposition, and that's exactly what we did. But we always kept them in the loop. February 25th, email from us to them, letting them know that we're moving towards RFADA. And then again, on April 26th, letting them know that we are making these amendments and then we are making the changes, and that if they have any concerns, to please raise those concerns with us. However, those concerns were not raised until last week, where they decided to come out with an opposition letter. And I will state that RFADA has passed in 11 other states. And in all of those cases, not one state did ACLU oppose the bill. Not in one of those states. So I just wanted for clarification.
And I appreciate that, although let me reiterate that California has a very distinct constitutional protection for privacy that is written right into our Constitution. And so we have a responsibility as California to recognize that fundamental constitutional right to privacy. I'm not saying that we are or we aren't, but it does distinguish us. And so as we proceed looking at some of these uniform acts, particularly as they pertain to privacy, we have a much higher bar than most other states. But I appreciate, and it's my hope that we can have a little more discussion about some of the questions and issues that were raised. So, Senator Wieckowski.
So I think if I'm reading the staff report on page 7, rolls into 8, usually in the probate world, it's the last will that survives. You can have a will, holographic will, another will, that's controlling. Here, you're saying that if you have an online user, you had the opportunity to say, I don't want to share this information, and you don't click the button, and then this will gets done later on in time. I mean, there's no sequencing here. I get it that I have a will, and then I get an email account, and then I get all this data in there, and then I click on it. I get that in time. Now you're saying no matter what the will is, or when the will is the last thoughts of the deceased, that sort of bugs me. That, am I reading that wrong, or is that the law? Or is that the way the bill is?
You're close, Senator, but I want to say you said you forget to check it. That's not the way the bill reads. The bill says a user may use an online tool to direct the custodian. So it's not ignoring the online tool, it's utilizing the online tool. And once you do that, so if you're in your Twitter account or your Facebook account, and they have an online tool, and you go into that and you use it to tell somebody, this is how I want my Twitter account taken care of, we are under the impression, and the Uniform Law Commission are under the impression, that that's probably more relevant because you're inside the Twitter account or the Facebook account than a generalized thing in the will. And so the Uniform Law Commission wrestled with the same issue, and what they said is, as long as that tool is not set in stone, and that you have to interact with it and direct it, and you can change it anytime you want, that is probably the most accurate thing about how somebody wants their Twitter account used. You do have to sort of, it does not use a lost in time, it does use a modal way to look at it, but we think for a good reason.
So how does that help the personal representative who's trying to marshal the assets of the estate? I mean,
so if the person has gone into Facebook and said, I do not want this data disclosed, it won't help the personal. I mean, that is the fundamental tension we have, is that we want to protect privacy, but we want to help administrators do their job. Maybe if you switch to like an email setting online tool, if the person has said, I do not want my content revealed, that does not mean that the administrator couldn't still find out some information about who have you been talking to and how have you been finding out from Wells Fargo that you're getting financial statements. But we do default to a process to try and figure out what did the user want the administrator to have, and if there is no clear indication, at least there's a default to give them as much information as available under federal law.
One of the opposition and the proponents have talked about electronic communications are somehow very different, very special, and to some extent, that's true. In other extent, it's not. If I have a secret house that I've got, liaisons or, compromising pictures and all those things like that, when my personal representative finds out about it, or a storage facility, they get to go in there. They walk in with their letters and they say, hey, owner of storage facility or here or condo complex, I've got the letters. This is property of this estate. I want to administer. I want to find what it is, and maybe there are some things that people don't want to have public, that they want to keep very private, but that person's dead, and at that time, the landlord doesn't get to act as the custodian, or the people that work at those storage places. They don't get to say, oh no, this is really private. This is where the girlfriend was at, or whatever the deal was. So why are we making? Why does the opposition object to the nature of the communications, or give it some sort of extra special quality? And the proponents, why don't we, once the person is dead, why does that continued vigor towards protecting privacy exist?
Thank you for the question, Senator Wieckowski. Let me just say briefly on that point. The bill doesn't, you're right, distinguish between the content of the communications. All electronic communications are treated exactly the same, whether they're about private matters or not private matters, right? But typically, electronic communications have been treated differently in the law. Recently, the United States Supreme Court in the Riley versus California decision said these are really different, in part because we tend to somebody else has custody of them, and we don't tend to manage them in quite the same way. They sort of pile up, right? Mm-hmm. And we don't delete them, and we're not as selective about what we save.
Or shred them.
Right? Or shred them, as the case may be. But let me pick up on the other points you raised, which I think is very important, and I just want to be clear about this. The user settings, this online tool, is going to trump a will. And I think that's unusual. even if the will comes afterwards. So if an expression of the decedent's intention is to keep something private, but they haven't gone back and changed all of their settings on each of those individual accounts, their will is not going to be effective, even if it is the last expression of testimony intention. And they're not going to be told that either, right? Which I think is going to be contrary to most people's expectations. Usually I think they're going to say, my will is the thing that's going to control this. And that's different about this. So I just want to address that issue.
On fees, the bill provides for, I haven't done a probate in years, but you're able to collect fees. If I go into Wells Fargo and say, give me 5 years of bank statements, they're able to charge me for that, whatever their copying costs and all that. Is that the flavor of this provision, or is it, because you objected to the fees that are able to collect to sort the information and get it through? And if I go in as a probate representative or personal representative, if I go into Wells Fargo and make a request, they don't have to do that for free. They can charge the estate. Is there something different or that we're expecting under?
The reasonable fees are available.
I think,
Right. It's pretty standard probate sort of language.
all right, that's enough.
And if you don't mind, if I don't add, this is also, what was mentioned before, to create a process that doesn't necessarily exist right now. The problem with right now is that if you want to get this information, you can't get the information unless you sue the company. You take the company to court, and then they're going to say, no, we're protected under federal law, there's no consent. And so the only way you get in is if the judge says, no, you have to let them in, and they get a court order, and then they'll give you that information. This is setting up a process by using consent. And so, as far as we're concerned, this is making it easier, while also at the same time protecting people's privacy by giving individuals the power to make that determination for themselves on their own. We've heard through the course of just coming to this committee, hey, require them to create this tool or have them this. All these companies are moving that way. So if that's something that's already going to be there, let them do that, because that's where they're going to be and that's where they're using this information. If not, then you have the will. If not, then you have the terms and services. If for some reason all those three don't match up for your specific situation, well, then you just go back to what's existing law. But we think we're making this issue a lot easier.
And if I may, I think if you put in a will that the will supersedes any other directives that have been given, the will prevail. But that's something that we can look at, because the goal here is to recognize how people use the internet, what their expectations are, and then what needs to be done in order to probate an estate or to close out an estate if you don't have a will and all. We've got to figure out a way that we can access that information, protect people's privacy, but also, people die and their affairs have to be concluded at some point. So that's where we're trying to reach this balance. So I appreciate the concerns expressed by everyone and the hard work that's been done on this. I'm not sure it's a perfect world, but if there are some, I'm sure there are other questions. So Senator Anderson.
One of the reasons why I'll be supporting this today is it's a path to those assets. We know that everyone uses online banking. Everyone's going through technology. And if you don't have access to that, you don't know what you don't know. And the concern I have is this may not be a perfect goal, but technology is evolving. And I think that as we address issues with this, we can come back and retweak it. But as it stands today, as I've read and understand, we don't have access to it at all. And so I think this is a stepping stone in the right direction to deliver on those who want to engage in that way. And for those reasons, I'll be supporting this bill.
Thank you, Senator.
Thank you, Senator Anderson. Senator Moning.
Just very briefly, I agree. I applaud the author of the work you've done on this. It is timely. It's critical that we move forward. The engagement of prior opponents who you've been able to get to this point. But maybe I'm not understanding it right, but I do share the concern on what you might put in a will versus what you might have clicked with an online account. If I get on a Wells Fargo account something that flashes up at me and says, is it your preference that we don't share your information with anybody? My instinct is going to be say, yes, I don't want you sharing it, or no, don't share, without thinking of potential probate or estate issues down the road. Then in a will or a trust, I'm very explicit that I want my surviving spouse or administrator of the estate to access any and all accounts. I might even list those accounts by name of institution and account number. Am I correct to understand that even with that directive in my trust or my will that specifies the specific account, that if I've clicked on that account saying I don't want it shared because I think it's to protect me from hackers or the bank having a commercial interest in sharing certain data about me, does it create this problem? Am I stating it right, or please help me understand?
Sure, Senator. I mean, this is one of the, trying to figure out what's the best way to hear from a decedent is something that the ULC wrestled with. One thing I would keep in mind is that when you're talking about electronic communication services, you're talking about Match.com, you're talking about Facebook Messenger, you're talking about all of these things that may or may not come to somebody's mind in the will. Right, so I understand why people are wrestling with it, but the reason the ULC sort of defaulted to an online tool, which is not click, everything's private, but it's like, do you or do you not want this information to go to your designated recipient, right? So it's not designed or meant to be a broad, just keep everything private. It's an online tool that's meant to be used to prepare for your eventual passing. So that's why. And the thought is that when you're in a Twitter account, you might say, my representative doesn't need to see my Twitter account. My representative does need to see my Google account, right? So you know, you can do that. And so because there are so many different electronic service providers, the general compromise was that that's probably the most accurate issue. Under this language, I tell you, under this language, that does take precedent over the will, even if the will happened last week. Right?
That's helpful. I mean, I can understand, I think it's consistent with the opponent's concern about privacy protection. There may be a dating service or some other online service that I explicitly don't want that shared ever with anyone. But I am,
wife.
yeah. Well, that's where Wachowski was going. I've got nothing to hide. My concern is the more commercial implementing your estate and not having roadblocks to accessing bank accounts or information necessary to fulfill your wishes in your will or your trust.
Can I just follow up one real quick thing? So the default there.
Excuse me.
Yep.
Quick, through the chair, and then we're going to, okay,
Absolutely.
thank you.
Sorry, Madam Chair. Thank you. So the default there in that case would be you could still get the, so you know, in a Gmail account where you're trying to figure out, okay, where are all these people's assets, you could still get the catalog of communications that said, on the 21st of every month, Uncle, John got something from Wells Fargo, right? So, you know, every month this came at the same time. So a lot of, 99% of what you need to do to administer an estate, which is to figure out where all the assets are, would still be available, okay? So it's the difference between content and the information that, in fact, Schwab, Wells Fargo, and Prosper Loans are all communicating with the decedent. Those secondary things would still be available even if the online tool was used to say, don't share my content.
And then just a final question. How do they communicate with the decedent? That one is really beyond me.
That's a good question. Emails come after you die, but you're probably not receiving them. That's a good point.
Thank you. Thank you, Madam Chair.
All right, any other questions? I think I want to commend the author and your patience and all those working on this bill. I think that there is still some room for work here. As I think about this, to undermine the sort of the longstanding tradition that a will is the final word, I think is going to create some problems. And while we've been talking about this, and I appreciate the attempt to create a system that is going to recognize how people use the internet, but also be kind of consistent, respectful of the whole testamentary infrastructure that we have in the state. I would ask that we continue. I know this goes next to the floor, but there is no, is there a time limit here?
No, I mean, you could choose to.
Yeah, I think, and you know, this is such a new area, and I know, and I do respect the efforts that are being made, and I think we need to do this. And I do appreciate that there will be some tweaking at some point, but if we see some of these issues in advance before we actually pass the legislation, it seems to me incumbent upon us to try to do that. So I would propose that either we keep working on this or that we can move it to the floor with an understanding that we will keep working on this. And I'd like to see if we couldn't get some members of TexCom to perhaps join in this effort, because if we're going to end up with an instruction on the internet trumping a testamentary statement, this could create some real problems going forward, or not, but it seems to me that it would. My instinct is that we really need to have a thoughtful discussion about what the implications will be if we allow a setting on the internet to prevail over a testamentary document. I don't know, that maybe that's the future, but I would like an opportunity to continue that discussion. So we can either hold it in committee and continue that, or we can move it to the floor with the understanding that we'll keep working on it before it does go to the floor for a vote. I mean, that would be my recommendation, and if you would agree to continue working on that before we do take a vote, I don't care which approach we use, but I really think we have to continue this discussion. If you'd be willing to do that, I will support the bill. Otherwise, I don't feel comfortable at this moment.
Well, I think we'd like to move it out of committee. I mean, I think we've shown our ability to continue to work with the committee. Again, this is our third time coming here. But
Tough issue. I mean, you've really taken on a huge, I commend you for it, and you still don't have gray hair. So, you know, this is good.
I know. So I think that we've demonstrated the ability to work with the committee and to get something as workable as possible. You know, last time we left, we said we'd work with the opposition. That's why we're back here today. We will continue to work with, like we said, we've made the commitment to continue to work on the encryption aspect of it. We're more than happy to do so, but it would be our desire to move forward on the bill today.
I understand that. So my request to you is a commitment that before we bring this up on a vote on the floor, that we continue this discussion that we've been having today. I'd also like to include I don't know whether we're going to reach that level of privacy. I don't know if it's feasible to do that, but something to address those concerns, or at least to have that discussion. But I do think we need to resolve this issue, and I hear my colleagues indicating a need to resolve this issue about, are we going to now change the rules so that testamentary statements are no longer the priority, that we're going to let something else, I hate to use the word Trump these days, but we're going to let something else trump us on this issue. Can we get that commitment?
Yeah, absolutely.
All right, very good. So is there a motion? All right, with that understanding, as amended with the agreement, it will go to the floor, but we won't take it up until we can continue this discussion and try to resolve this. And I do believe that you're operating in good faith. I think we've come a long way, but this is a really, this is just addressing a technological reality that our social structure really isn't prepared or hasn't been prepared to address. And so trying to bring that together, I think, is very important, and appreciate your willingness to continue that discussion. So with that, is there a motion? Motion by Senator Wojciechowski as amended to the Senate floor. Oh, we cannot amend. I'm sorry, it's due pass to the Senate floor. Amendments potentially taken at that.
My motion is due pass to the Senate floor.
I knew that. All right, very good. Please call the roll.
The motion is that the measure be returned to the Senate floor for consideration. Jackson? Aye. Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Leno? Monning? Aye. Monning, aye. Wojciechowski? Aye. Wojciechowski, aye.
5-0, we'll hold the roll open for the absent member. Thank you very much.
Thank you,
Appreciate the conversation. Okay, so what do we have next? I think we are. Yes, so let us go in order. File item 6. We'll take Senator Anderson's file item 6, and then file item 12 by Senator Anderson. If you'd like to proceed, or would you rather wait? All right, well, then we'll go. We've got several members. Senator Monning is ready to go. We'll take file item 7. This. Almost good evening, but Senator Monning, we're on file item 7, SB 1092.
Thank you, Madam Chair and members. SB 1092 requires short-term home sharing companies who operate through an internet hosting platform to provide a disclosure to homeowners or tenants listing their property about the need to review their insurance coverage to ensure they are covered in the event of injury or damage during the rental period. Many homeowners and renters list their residences for short-term rental on internet hosting platforms, such as Airbnb, HomeAway, and vacation rentals by owner, to name a few. Unfortunately, many are unaware of the insurance ramifications if damage to property or injury at the property occurs during the rental period. Most current homeowners insurance policy allows some period of limited commercial use, but the terms can vary significantly based on the insurance company. If the activity is explicitly excluded by the policy, the homeowner or the tenant may be liable for injuries or property loss. It is important for homeowners and renters who make their properties available through the internet hosting platforms to understand their insurance coverage fully and whether it will protect them. SB 1092 simply requires these websites to provide notice to the homeowner or renter to review their insurance coverage before listing their property. And I would ask for an aye vote at the appropriate time. Madam Chair, have a couple of witnesses here to testify on the bill. Thank you.
Thank you very much. Good afternoon.
Good afternoon, Madam Chair, members of the committee. Armand Feliciano on behalf of the Association of California Insurance Companies. We do support the bill. Just a quick background, this bill builds upon SB 761. A bill last year by Senator Hall required a similar disclosure for tenants to check their lease make sure that they're not violating the lease when they participate in such programs. We're trying to build on that. We feel it's good public policy for our policyholders to go check their insurance coverage. Thank you.
Thank you. Good afternoon.
Good afternoon. Good afternoon. Sherry McHugh, representing the Pacific Association of Domestic Insurance Companies. We are also in strong support of the bill. For many people, their most valuable asset is their home. SB 1092 will just help to ensure that people check with their carrier, their agent, or check their policy to make sure they have proper coverages in place before they list their home on a hosting platform. Thank you.
Thank you very much. Other witnesses in support, if you'd step forward, give your name, affiliation. Thank you. Other witnesses in support? Any witnesses in opposition? All right. Looks to me like we have an opposition?
Well, no, just an additional comment, a neutral position on the bill at the moment. Greg Hayes with KP Public Affairs on behalf of Airbnb, and we definitely appreciate the author's intent with the legislation. We are working actively with the author and his staff on the language. Airbnb, for the record, does offer insurance coverage for both liability and property damage to people using its site at no cost to the people hosting on the site. And we believe alerting people to that, the need for that and that type of coverage is important. How you do that is also important. And we want to make sure it is done in a way that it captures people's attention and is done in a relevant enough way so they pay attention to it, and that there's some potential noodling on language with that. Right. But we do appreciate the author's intent and the cooperation so far.
Thank you. Right. Much appreciated. Any other witnesses in strong neutrality or? No? Okay. All right. Senator Monning, if you'd like to close, unless there are any questions? No? All right.
Be glad to close. We are engaged with those that weighed in neutral and think it's a good bill. Respectfully ask for your aye vote.
Very good. Is there a motion? Senator Wieckowski moves. The motion is to pass to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg? Leno? Monning? Wieckowski?
Aye.
Wieckowski, aye.
Did you get me?
Oh, sorry.
Sorry.
Monning, aye.
Thank you.
All right, 5-0. We'll leave the roll open. Senator Anderson, you ready to go? All right. File item 6, Senator Anderson, SB 1057.
Madam, I'd like to